Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the Phia Group.
Hello, everyone, and welcome to another exciting episode of our Empowering Plans podcast. I am Jen McCormick, and I'm here with John Jablon, and we have an exciting topic to cover with you today that is increasing in significance, importance, and how this issue is being addressed in a variety of new compliance and regulatory topics, and that is stop loss. There are oftentimes situations where we are involved and people solicit our help to address potential gap issues or disputes that might arise, or hopefully coming to us to proactively prevent these issues from arising in the first place. This is such an important topic because it not only is something that needs to be addressed in the plan documents and the plan materials and amendments as the rules and regulations are changing, but as the rules and regulations are changing, making sure that that modification is in line with the existing stop loss policy or the renewing stop loss policy. All of those pieces are crucial to make sure that you are not creating a gap or surprised by a problem that could arise later on. So all of this starts by looking at the materials, reviewing the materials, and making sure that you are generally comfortable with what they say, what they mean, and how they can be interpreted. And with that, John, I'm going to turn it over to you and sort of get your opinion. I know this has been something that you have been heavily involved in, working on a ton of these reviews and disputes and proactively looking to collaborate with those in the industry to make sure that we can do all we can to prevent problems from happening in the first place.
Yeah, thanks, Jen. Stop loss is incredibly important for self-funded plans. There's absolutely no doubt about that. And we've all been helped by stop loss in some way or another. Right. And, no one's going to deny that stop loss is just so useful and an excellent tool and generally a great partner. That being said, stop loss is an insurance provider, just like a health plan, and it needs to contain costs. No one can really expect stop loss to blindly reimburse for medical claims based on whatever the plan decides to do. There's a policy. There is a stop loss policy that defines the parameters of what the carrier is or is not going to pay. And Jen mentioned, and she's absolutely right, of course, that it starts when you read the policy. Read the policy. It should go without saying that that needs to be done, but we are constantly amazed when we hear from a broker or a TPA or a plan and we say, hey, didn't you read this policy? Didn't you know that this gap was potentially here or that this limitation was in the stop loss policy? And the answer we get sometimes is, well, no, we trusted this carrier. They said that it was a great policy and we just kind of took it and ran with it. And the lawyer in me wants to scream that the policy wasn't read and analyzed, but the benefits professional in me realizes that, well, yeah, this kind of happens a lot. People just take someone else's word for the fact that this is a great policy, right? Maybe a broker approves a policy renewal without really analyzing the changes from one year to the next. It happens all the time. Easy mistakes to make, but the point is, those little changes from year to year, one exclusion added, one definition changed, even by just a few words, that can make the difference between a claim being accepted and a claim being denied. So sometimes we analogize stop loss gaps to a person seeking treatment but having a claim denied by a self-funded health plan. The person needed the treatment just like the plan needed to pay the claim, but the health insurance, right, the self-funded plan may not cover it per the terms of the plan, just like stop loss may not cover a claim per the terms of the policy. It's sort of the same thing where you've got two entities that are sort of working towards the same goal, but using different criteria for whether a claim should or should not be paid. So when plans expect all stop loss claims to be paid no matter what period, that's a mistake. Simply put, it's not that simple. I mean, if it were, this would be a very different industry, right? Because we could rely on stop loss to just have our backs no matter what period. But the fact is, stop loss has to contain costs just like we all have to contain costs. And that's where this gets a bit complicated.
All right, thanks, John. Yeah, that's definitely a great answer. And I think that this is something, while we have discussed this, and this has been a continuing topic for us for a number of years, this is still relevant today, and it's becoming more and more relevant as we've seen so many changes just in the past 8 months for plans that we have not seen for the past 8 years with the NSA, the Consolidated Appropriations Act, all of the concerns with mental health parity, and last but not least, the Supreme Court decisions that have come out about dialysis and how abortion is to be addressed. There are a lot of things now that mean that it is critically important to make sure that we are addressing this. And because of that, we need to make sure that every opportunity that we have when it comes to containing costs, we can take advantage of. And we can make sure that this is not only addressed in our underlying plan documents, as John noted, there are distinctions about how the plan would interpret something versus how the policy would interpret something, but that we close those gaps to the extent that we can, since we're referencing a lot of these key terms. One of the big examples that we talk about, especially now that the NSA seems to be top of mind for a lot of plans and a lot of employers and a lot of entities that are out there, we're talking about how claims are being calculated. How are we deciding what the allowable amount should be? How are we deciding how to calculate this? What parameters we should be using? How we're defining this within the plan? And how we're going to address this when this comes to the actual in-network claims as well. So from the out-of-network side, generally we're using UNC or some variety of different factors and parameters to come up with our maximum allowable charges. But when we look at the in-network claims, there's that PPO network that isn't a party to the contract with the stop-loss carrier, and it's not a party to the plan document. This is a separate contract, a separate document that outlines how certain claims should be paid. So it could potentially put us in a bit of a bind if there is something within a network contract that's not clearly defined within the plan document, or maybe isn't 100% aligned, or could be a little bit different, or even assume it is 100% aligned. That doesn't mean that the stop-loss carrier contract couldn't have a contrary provision or even a mirroring provision that would allow them to interpret the plan document differently than the plan document is interpreting the stop-loss policy. So you have this trio of different documents that may have a separate term for how claims should be calculated in network, out of network. That puts the plan in a bit of a spot because they still have this fiduciary duty to make sure that they are administering the plan in accordance with the terms of the document. So how can a plan then make sure that they are administering the terms in line with the plan document while being bound to potentially 2 other contracts that have differing terms? I think that creates a lot of trouble here, since plans need to make sure that they are doing all that they can to put themselves in the best spot from a compliance perspective, but also from a cost containment perspective. John, is there anything that you wanted to add about RBP plans in particular?
You know, I could talk all day about this, and in the past I have talked all day about this, but I'll try to keep from doing that right now. The simplest example of when this happens is when a reference-based pricing plan says something like, we will pay 150%, for example, for all claims, and the plan pays 150%. And then the provider comes back and wants to negotiate. Now, sometimes provider negotiations are wildly unreasonable, right? Like a provider will come back and say, we demand full bill charges, and the plan says, no thanks. But sometimes providers want to negotiate in a more reasonable way. So if, for instance, a provider said, well, I won't take 150% of Medicare that you already paid, but you know what? I'll take 180% of Medicare because that's our normal reimbursement. A lot of plans will look at that as, well, 180, somewhat reasonable, right? We paid 150 as a starting point. 180, sure, let's do it. Let's get this settled. We don't want any balance billing, so sure, we'll pay 180. Well, if the stop-loss policy doesn't allow for those additional negotiations, which frankly, I've never seen one that does, stop loss might look at that and say, we did not approve this additional 30% of Medicare. We didn't underwrite it. We didn't know you were going to do it. You just chose to do this. And the plan says, well, yeah, we did it to save money. We could have joined a PPO and paid 5 times this by contract. But instead, we decided to go with an RBP, a reference-based pricing methodology. And part of that often is negotiating a bit more payment to achieve all the savings we want. But we see the carriers saying, but we didn't underwrite it. What we have underwritten was what the plan document says, 150% of Medicare. You paid 180%. Therefore, we are going to deny the additional 30% of Medicare. It's a big problem when it comes to reference-based pricing. And I don't want to say there is no solution. It's a tough solution. But of course, like so many things with stop loss, the solution is have a conversation. We certainly can't guarantee that the carrier is going to agree with the plan's mindset and agree to reimburse those additional negotiated rates, but having a conversation is the only way that it even becomes possible. So if you go to the carrier and say, look, we've got this provider, they want to negotiate, they're asking for 180% of Medicare. We think that's really reasonable. Will you agree to reimburse that? The worst the carrier can say is no, and then at least you know what boat you're in. But if the carrier says yes, because, thank you for trying to save yourself money, which in turn saves us money, fantastic, then great, everybody's happy. So, it's really a balancing act between the plan trying to save money itself and the carrier needing to save its own money and really go with what it has underwritten and make sure that it's not paying benefits that it sort of doesn't expect. Because just like health insurance, stop loss is all about risk. If the carrier doesn't know its risk and the plan ends up giving the carrier risk that it hasn't underwritten, a lot of the times the carrier is going to say, sorry, we can't pay this because you never told us it was going to happen. We had no way of knowing. So it gets really tough in general. I mean, this is an example relevant to reference-based pricing plans, but the concept of gaps and of the carrier needing to cap its risk based on expected parameters, that's inherent in all gaps. That's sort of the point of why we're having this podcast and the reason we've been talking about mind the gap for, 15 years, maybe more. I think it was definitely before I came to Phia, which was 9 years ago. So, gaps are very relevant to almost every aspect of the plan and policy, and everything has the potential to become a gap. Not everything will become a gap, but everything has at least the potential. So Jen, I'll give it back to you now if you want to talk about some medical tourism. It's a super fun issue. Domestic medical tourism is certainly more relevant now than it has been any time in recent memory, but international medical tourism continues to be an issue between plans and stop loss.
Yeah, thanks, John. Definitely, this is something that is becoming more and more relevant as the rules are changing in light of the Dobbs case. The first big issue over time that we have seen is, as you mentioned, international tourism, medical tourism, and how that should be interpreted in the plan. It was not uncommon and still not uncommon for us to run into a situation where there is a policy, a stop loss policy, that completely excludes all foreign treatment, all foreign travel. So if you're going abroad internationally, seeking treatment for a particular course, whatever that may be, it's something that is international. If you're going for the purpose of getting medical treatment, it is not covered by the policy. But then you have these plans that are trying to be super innovative, looking for ways to create opportunities to contain costs, but still providing some high quality treatment for their plan participants. And one of the things that they are thinking and investigating is international tourism for medical purposes. So they'll work together with companies and different entities, medical providers, to provide the opportunity for participants to travel abroad internationally to seek that medical care that they might need. And this is saving tens of thousands of dollars, in some cases even more, for this opportunity for this medical procedure to be provided internationally. So they'll make all of the changes to the plan document, all of the changes to alert and let everybody know about this new exciting opportunity. But what they forget to do at times is to check in with the stop loss policy that they have, because that's something that they had put in place. They thought they had signed off on it when it came time to renewal. So by putting this new innovative cost containment strategy for medical tourism internationally in their plan, they're really putting themselves in a bind by not checking back and creating a hard gap there. So the moral of the story is, when it comes to international tourism, whenever there would be the opportunity to create a program like this or put a cost containment strategy in place, whether it's this or another one, checking back with the underlying stop loss policy to make sure that even if you make a change to the plan, that you make the change to the policy or you address that somehow and in some way, even if it is going to save money at the end. If there is a gap, that's going to create a problem for reimbursement. So there are oftentimes certain procedures within the policies as well that outline how and when notice must be provided to the carrier in order to adopt or sign off on a particular change. So it'll be important to address that as well. And domestically, as we sort of noted here with the Dobbs case, we're seeing a lot of plans that are looking to implement a travel benefit. And while it's not uncommon to have a travel benefit, normally these are benefits that we see within a plan specific to reimbursement for a companion or for travel or lodging when it comes to an organ transplant. But now we're seeing in light of the different state stances on how abortion benefits are or are not covered or permissible, that plans are looking to have their individuals have the opportunity, should they wish to travel from their current state where they're located, where maybe an abortion wouldn't be permissible at a particular stage in the pregnancy or at all, and allowing the opportunity for those employees to travel to a different state. And they're putting in this benefit, an abortion-specific type of travel benefit. But one of the potential concerns in doing this and implementing that plan language is how the stop-loss carrier then could interpret that. So if there was a situation where the employer did allow this benefit to be put into place, could there be a situation where the stop-loss carrier would then say, great that you have that benefit, but it's our interpretation that by you allowing the employees to travel out of state to get this procedure, that is not in line with the terms of how we'd interpret that provision. That's not permissible. We consider that to be illegal. We consider that to be something that's not eligible for reimbursement under this plan. So however this benefit is being created or modified or adapted for the particular plan, even in a domestic setting and not an international setting, there's still the opportunity for there to be a potential gap in how this is being interpreted by a carrier. So even if this is a benefit that is still covered by the plan, there's no change to how the benefit is being operated. If there are certain expenses, and now that these state laws are varied across the country, it's another check that you'll have to do with the stop-loss carrier to make sure that you're not creating any other gaps or openings to how to interpret something different from how the plan and the carrier would see that. John, before we move on to occupational issues and those types of gaps, is there anything else that you wanted to add, or otherwise I'll let you take over?
No, there isn't to that. I think that this gap, maybe more than any others, shows just how complicated this stuff can really get, especially with, let's call them current events, right? With everything that's going on, gaps are changing. This is an evolving topic we're talking about. This isn't just like, oh, someone discovered that there's a list of 10 gaps to look at 10 years ago. No, this constantly changes. And frankly, since every policy is different and every plan is different, they have the potential to have a very, very different set of gaps. And Jen, in the interest of time, I would actually love to skip occupational, and maybe we can finish up by talking about employee handbooks and collective bargaining agreements and stuff like that, because we've been getting a lot of questions about that lately. So are you good if we just talk about that and then let our listeners go?
Yeah, absolutely. The only note that I wanted to bring up about the occupational injuries is just a reminder that COVID still exists. So to the extent that that plays in as far as the current events, just a consideration about how and whether your state would have a presumption and how that would interact with your plan versus your policy. Just a note, and with that, I will let you take it away and wrap us up.
Thanks, and thanks so much for reminding us that COVID still exists. I had almost forgotten about it.
You're welcome.
Now it's fresh in my mind again. Great. So the last thing I want to talk about today is employee handbooks and collective bargaining agreements and agreements like that. They present their own gap issues with a plan doc. We do gap reviews primarily between a plan document and a stop-loss policy to compare them, but we also do gap reviews between plan documents and employee handbooks. The most prevalent issue seems to be leaves of absences. For instance, if an employee handbook provides that an employee can be out on an approved leave of absence for 6 weeks and continue health benefits, the plan document needs to align with that. If the plan document doesn't allow for that 6-week continuation, we've got a problem. Ultimately, if it went to court, we do believe that a court would say that the plan is actually obligated to provide that additional 6 weeks of coverage. But guess what? The stop-loss policy, it doesn't. The stop-loss policy doesn't cover the plan for that 6 weeks of leave that the plan did not actually guarantee. Again, it comes down to an issue of underwriting. The carrier never saw that 6-week leave of absence. It had no reason to expect that a person was going to be out of work for 6 weeks, but still covered by the plan, because the plan might not say it. That is where the gap issues between a plan and an employee handbook get very, very important. So it's also important to note that even though the plan might accidentally offer benefits within a handbook that it doesn't actually offer within a plan, it's important to notice that most policies even explicitly say that they will not take into account any benefits that are guaranteed by other documents than the plan doc. A lot of them even specify that they don't care what the employee handbook says. Obviously, I'm paraphrasing, but a lot of policies mention the employee handbook as a document that it will not consider when determining its benefits. So in other words, the carrier is saying, look, whatever benefits you're offering, you better make sure that they're in the plan doc because that's the document we're basing your benefits on. If you're offering benefits within some third-party agreement, like a handbook or a collective bargaining agreement, we are not underwriting that. We are explicitly not underwriting that document. Whatever the employer's leave policies are, you better put it in the plan doc because that's the only place we're going to look. And it gets really interesting, and by interesting, I mean complicated and sometimes sort of terrible, with respect to plans that do inadvertently offer leaves of absences and continuation of coverage during those leaves of absences, but they don't put them in the plan document. Stop loss looks at that and says, well, it wasn't in your plan doc, so we're not going to cover it. Again, the only way to alleviate this is to have a conversation, or I guess it's not the only way. The best way is to make sure that the plan document says what you mean and mean what you say. But if the plan document is silent on certain benefits and continuations of coverage that are in fact offered, it's always going to be a problem and it's always going to be a gap. So Jen, any final comments on this, and whether you have them or not, why don't you take us out of here?
Yeah, so in summary, review your materials, review your policy, review your document, continue to update them and review them as the regulations change, the rules change, the current events are happening. It's time to pay attention. So with that, I want to thank you all for listening to us today talk about stop loss issues, and hopefully we've been able to provide some background and considerations on how to preempt or address some of these issues before they become problems. On behalf of myself and John, thank you so much for dialing in to another episode of our Empowering Plans podcast.
Thanks so much, everybody.